Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here to talk about the California Appeals Court that has extended the time that companies like Uber, Lyft, and I believe DoorDash have to comply with the AB5 law that was put into place in California, which basically designates who is considered employees and who are considered independent contractors. And according to the formula that was created, it was determined that companies like Uber and Lyft, they cannot have contract employees. They must hire these people and treat them as employees. And so Uber and Lyft were prepared to shut down at midnight tonight, I believe it is. But the appeals court gave them until September to comply with the law. But they're basically saying that they want to fight this ruling. And so for those of you who are not familiar with the AB5 ruling, let's talk about that. It says California Assembly Bill 5, AB5, popularly known as the Gig Worker Bill, is a piece of legislation signed into law by Governor Gavin Newsom in September of 2019. And it went into effect on January 1st of this year, and it requires companies to hire independent contractors to reclassify them as employees with a few exceptions. The bill expands on a ruling made in a case that reached the California Supreme Court in 2018, which was Dynamex Operations West Incorporated versus Superior Court of Los Angeles. And so the impact of this law is that independent contractors, which are basically people who work for companies but work on their own terms. They're not employees. They don't get benefits or anything like that. And they just basically work when, in most cases, they work when they want to work. I know my mom retired from Verizon, and then after she retired, she went back as a contractor. So she still worked 40 hours a week. You know, she still had benefits and that type of thing, but she wasn't an employee. A lot of people that work for companies like FedEx, Amazon, UPS, those are independent contractors. They're not subject to the same things as someone who's hired by these companies. And one of the big differences is that even though these companies will have people that are independent contractors, they also have employees that, you know, work 9 to 5, like their payroll people, the technology departments that's behind these apps. And that's one of the things that Uber and Lyft argue. They're saying that they're not a transportation company, that they're in fact a mobile app that allows people to make money on the side. And so this law, you know, it really impacted not only these type of companies, but it also impacted small businesses. My son-in-law has a cleaning company in California, and so most of his employees were contract employees. And even though he paid them, I think this bill forced them to bump everybody up to $17 an hour. He was actually already paying his workers $15 an hour, and so he had to give everybody out a $2 an hour pay increase. But his employees are based on the number of clients he has, so he can't hire 100, workers and say, okay, I'm gonna pay you $17 an hour for a 40-hour week. You're going to get health insurance and all these other benefits. And then half of his clients call in and say, oh, I don't want, cleaning this week. And essentially that's what happened to him when the whole COVID-19 broke out. Was a lot of his clients said, hey, we're going to have to put this on hold because we don't want people coming into our homes. And so for a small business, this has really impacted his bottom line because he offers a service where people can come up and say, I know last week you guys came in twice a week, every week, but this month I can only afford to have you come in one day a week. And so what happens is he was scheduling his workers based on the number of houses that needed to be cleaned. And so this ruling has really, impacted his business, and I'm sure other businesses just like it. And so there were three terms that companies had to look at in determining whether or not the people that work for them could be classified as independent contractors or they must become employees. And so one was the worker is free to perform services without the control or direction of the company. 2, the worker is performing work tasks that are outside the usual course of the company's business activities, and the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work that is performed. And so it says the test holds companies to a higher standard, improving workers are independent contractors than was previously used in California. AB 5 makes this test the new gold standard requirement for companies that hire workers in the state of California. So thank God this is only happening in California right now, because if it spreads to the rest of the country, it's going to be quite an interesting proposition, and I think there would be a lot of lawsuits filed. And so the advantages and disadvantages of AB 5 workers, the most immediate implication of AB 5 is it's 1, 2, 3 test that I just read to you, is that it turns independent contractors into employees. The key factor for gig companies is 2, which says that anyone performing work for a company that is the same as the business of that company is presumed to be an employee. And they went on to say that under the new bill, if employers begin classifying gig workers as employees, it means these workers will be entitled to minimum wage, which, like I said, I think is $17 an hour in California. Expense reimbursements. These people are driving their own cars, so I think they would have to be reimbursed for gas. They would have to be reimbursed for repairs on their cars. If somebody in the car does something like throw up in the car, and they have to clean the car, that type of thing. Employee benefits. They would have to get breaks, lunches, and other benefits afforded to employees under California state law. In that sense, the bill creates a level playing field between those working in the gig economy and those hired as regular employees. And so what happens is you're going to have people, who love working their gig job because it allows them to work when they want to work, and when they don't want to work, they don't have to work. I know personally, I do content production, like write blogs for companies, do web design, that type of thing. And so when work is slow, like lately, with the whole coronavirus and a lot of small businesses suffering, then that means that my business also suffers. But there are companies out there, it pays less, for the articles that are written, but it does allow you the opportunity to make extra cash. Or like if I have a trip that I want to go on, I can, write so many articles every week, to make that money to pay for my vacation. And so what happens with these companies is you can work from anywhere around the world for them. But when this law passed, then they had to say, people that work in California, we're sorry, but we can no longer, you can't come on our platform and do work for us, because then they would have to abide by these California rules. And so some people want, to make more money. They want a more structured atmosphere. But I would think that for the most part, people who drive for Uber and who drive for Lyft want to be able to say, I'm not going to drive at all this week. Or they want to say, well, I need to drive 2 days a week, and I want those 2 days to be on Monday and Wednesday. But if I need some extra money, I'll do it on Thursday. And so they're essentially taking that away from these people. And so let's see. So they talk about the advantages and disadvantages. The signing of California AB 5 into law affects many, but not all businesses that rely on gig workers in California. More than 50 professions and types of businesses are exempt, including insurance agents, attorneys, real estate agents, and certain types of business-to-business contractors and referral agencies. Companies that are not exempt will have to take a close look at how they classify employees and independent contractors to ensure that they are not violating the terms of the bill. For companies that do reclassify gig workers as employees, the question of how easy to transition would be centered to the cost of transitioning. And I guess what the companies could do is basically make everybody part-time, because most part-time people don't get benefits. That's part of being part-time. And so with that, I think you're hurting the gig worker, because part-time is usually 30 hours or less. But what if somebody needs to, 30 hours or less might be okay this week, but next week I might need to work 40 or 50 hours. Then you get into the time and a half, the overtime and all of that. Then what happens with holidays? So I can see, basically people will say, well, Uber and Lyft, they can afford to, pay these people, they can afford to do this. But the core of the issue is this whole model was built on the concept of not having to have a lot of overhead, not having to pay these people, and that these people could essentially go apply for a transportation company where they do get all of that stuff. I know being a gig worker, to me, is like being self-employed. You set your own hours, you determine how much money you want to make. So the ruling today, let's go over and talk about that. So this is an article from NPR. It says that Uber and Lyft spent the past week threatening to shut down their ride-sharing services in California at the stroke of midnight on Thursday. But the companies got a last-minute reprieve from complying with the judge's order to classify the drivers as employees instead of independent contractors, as required by state law. On Thursday afternoon, an appeals court said the companies can keep operating with their drivers as independent contractors while they fight the order. The court has also given the companies until early September to come up with plans on how they would comply with the law. The threatened shutdown would have left hundreds of thousands of drivers without work and millions of customers with one fewer transportation option in California, which is among both companies' biggest markets. So you're talking about making hundreds of thousands of drivers employees. Like, can you imagine the financial hardship that this would have on these companies? And I know you're probably saying, but they're making, billions of dollars, they can afford to do this. But trust me, when you start paying people $17 an hour, you start paying for health insurance, you start paying for vacation time, sick time, them profits start to shrink. And considering that the whole concept of doing this was not to have these people as employees, so it is really going to be a big decision for them. And then they'll probably just come down to weighing, is it worth it to lose the California market, which is a huge market, or, they probably have accountants working on this right now, or will it be better to just comply, make everybody part-time, which they probably would lose a lot of drivers. I don't know. Last week's order by San Francisco Superior Court Judge Ethan Schulman created an existential crisis for the ride-hailing companies, which have refused to comply with the law known as Assembly Bill 5. In May, California's Attorney General, along with prosecutors in Los Angeles, San Diego, and San Francisco, sued the companies to force them to reclassify their drivers. The law makes it harder for companies to reclaim workers, harder for companies to claim workers as independent contractors rather than employees. It gives gig workers access to labor protections and benefits such as employer-sponsored health insurance, overtime pay, and paid sick leave, which they do not currently receive under their independent contractor status. Uber and Lyft maintain that AB 5 does not apply to them, saying they are not transportation business but a tech platform. After Shulman ordered them to comply with the law, with the state's lawsuit proceeds, Uber and Lyft said they could not make that switch quickly and would have no alternative but to shut down their services for an indefinite period. They warned that converting drivers to employees would force them to comply fewer drivers, reduce service, increase wait times, and raise prices, which is another important concept. I mean, I haven't called a taxi cab in forever. I have never taken an Uber or a Lyft. So my daughter, she does it all the time. She thinks that it is cheaper, it's really convenient. And so that's another thing that they have to consider. Like, are people, is the market going to be willing to absorb the increase in prices? Are they going to be able to absorb the wait times? Because it seems to me that now you're going back to the whole taxi cab model that people obviously wanted to get away from because this was more convenient. So critics say the companies have had ample time to comply with AB 5, which has passed last fall and took effect in January and stemmed from and I already told you about the Supreme Court ruling in that other case. Uber and Lyft have known for over 2 years that their drivers are owed basic labor protections like minimum wage, sick pay, and reimbursement for expenses. California Attorney General Xavier Becerra said California is America's economic engine because innovation and worker rights go hand in hand. Any company that suggests otherwise is peddling false choice. And once again, for me personally, that has done work for a company similar to this, but in the writing arena, I know if they came to me today and said, okay, we got to comply with this law, you're going to have to work X amount of hours, like we're no longer going to pay you per piece, we're going to pay you by the hour, I couldn't work for them anymore because technically I would be making less money by the hour than the potential I could earn by the piece, because by the piece, I then can determine how much work I want to do. But then I guess on the flip side, if they're going to pay me by the hour and then it didn't matter how many pieces I wrote, then I guess that would be a trade-off. But then I think they would pound more, they would pound more work and say, okay, here's a quota. You have to do X amount of articles a day. And for me, that would be too stressful and I would have to leave. And so it says the companies welcomed the appeals court ruling on Thursday. Uber spokesman Matt Kelman said, we are glad that the Court of Appeals recognized the important questions raised in this case and that access to these critical services won't be cut off while we continue to advocate for drivers' ability to work with the freedom that they want. And then that's another important aspect is people signed up to do this. So they weren't the ones that were arguing saying we should be employees. They were signing up saying because this model works for me. So Lyft spokesman Julie Wood said, while we won't have to suspend operations tonight, we do need to continue fighting for independence plus benefits for drivers. Both Uber and Lyft are encouraging customers and drivers to support a measure appearing on November's ballot in the state that would exempt the companies from AB 5. They have poured tens of millions of dollars into promoting the measure, seeking a political solution to their problems. At the same time, both companies are exploring ways to adapt their businesses in California in the event they lose their legal battle. That includes a franchise-like model in which Uber and Lyft would license their brands to vehicle fleet operations who would become responsible for the relationship with drivers. Drivers are divided. Many say they want to keep the flexible work schedule that independent contractor status allows, which the companies say they may not be able to maintain if they convert drivers to employees. But other drivers say they want the employment protections of AB 5. Then here's a quote from a driver for Lyft, and she says, by threatening to kill our jobs and leave California, Uber and Lyft have shown the world that they don't care about the drivers or their livelihood. And then neither Uber nor Lyft is profitable, and both have taken deep hits from the pandemic, which has decimated demand for rides and prompted the companies to eliminate thousands of corporate jobs. So I take back what I said earlier, that they're probably making billions of dollars. So that last statement that they're not even making money off of this, that it isn't really profitable, kind of puts me on the side of Uber and Lyft. Like, hey, we created this app, and and there's just so many apps to do everything, like grocery shopping, the food delivery business. It's just so many things that people do that, if they were impacted by this. And it goes back to, in one of my college courses, we read this book by this guy named Richard Florida, I think it is. And the book is about the service class, and it's basically talking about, how you had the industrial era, the technology era. Now we're in this service area where we're going to see like all these jobs go away that people once, were able to retire from, when they were 62 and have great retirement. And now we're in this service class where people are providing services, they're making less wages, and most aren't able to retire at 62 or 65 or whatever. And so this kind of like plays into all of that, with these apps that help people make the money they want to make for the hours that they want to. And I remember, and this is the last thing before I go, there was an article where this teacher here in Florida started doing the food delivery service, Ship, I think it's called. And he realized that for the hours that he was putting into teaching, because, teachers don't work just a 9 to 5, like they work around the clock, they work weekends. So he figured for the time that he was putting in to be an effective teacher, he made more money. So a teacher here makes like on average $47,000 a year, or I think it's like $47,000 a year on average a teacher in Florida makes. But if he put in the same hours delivering groceries, he was making $60,000 a year. And so he quit his job as a teacher to deliver groceries. And so I think it's a personal choice. And if the people that's doing it aren't complaining, why mess with it? And for the people that are complaining, like Miss Sherry Murphy here, then she needs to go get a job with a taxi service, who probably would give her the benefits that she's looking for. So anyway, guys, let me know what you think. Do you support Uber and Lyft, or do you support the state of California and this bill that they passed? If you are a Uber or Lyft driver, or have ever done that before, how would you feel about this situation? Like what side of the coin would you fall in? So go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.